As we're waiting for people to come back into the front of the auditorium, I want to express special thanks to Dr. Dilcia Granville, who's a member of the task force, for her helping first to get from the Food and Drug Administration the blue bags that were available to everybody when you registered. So Dilcia has made a wonderful contribution, and thank you for doing that for us. Here she is. I want to, at this point, introduce our luncheon speaker. The overriding topic or theme for this is social and human service providers stretched to the limits. And our speaker is the Honorable Edwina G. Richardson Mendelson, who's the Administrative Judge of the New York City Family Court. I just want to share with you some background for many of you. You know the judge from your work, and many of us who are not in the child welfare system may not know her. So I want to share with you some background. I think it's really very meaningful. Judge Richardson Mendelson was appointed to the New York City Family Court bench by Mayor Michael Bloomberg on January 24th, 2003. She served as a trial judge in Queens County Family Court until February 2008, when she was appointed supervising judge of the court. 1 year later, on May 6, 2009, Judge Richardson Mendelson was elevated to administrative judge in charge of all of New York City's family courts. Prior to becoming a judge, she served as court attorney referee in Queens County Family Court, presiding over child protective proceedings. Prior to that, Judge Richardson Mendelson practiced law for 10 years as a member of the assigned counsel panel, representing parents and children in New York County Family Court and Supreme Court matrimonial matters. She also served as the very first staff attorney for the Sanctuary Family Center for Battered Women's Legal Services, and was an attorney with the Legal Aid Society Bronx County Civil Division, where she represented indigent clients in housing court and in benefits entitlement proceedings. Judge Richardson Mendelson graduated from CUNY Law School in Queens in 1988, and she earned a Master's of Philosophy degree in Criminal Justice from CUNY's Graduate Center in 2000, and a PhD in Criminal Justice from the CUNY Graduate Center in 2002. That's an extraordinary background. A lifelong resident of the Bronx, Judge Richardson Mendelson is married to Dean Richardson Mendelson, Esquire, a court attorney and referee in the 9th Judicial District, with whom she enjoys co-parenting their wonderfully blended family of daughters, sons, and nieces. We are turning to Judge Richardson Mendelson to share with us what her experience has been in the family court and her career on the front lines with families and children who are in crisis, and how she sees that in terms of the resources that are available and how we might benefit from her experience. Judge, join me up here.
Thank you for that kind introduction. Hello, everyone.
Hello.
Good to see you all. What beautiful faces. I'm sorry to interrupt your lunch, but if I do, that means you will be falling asleep as I speak to you today. That's a good thing. he served, we were hired as referees together for family court, and he serves in the 9th Judicial District because I became an administrative judge. And as he likes to say, I couldn't be his boss both at work and at home. So he has to go. I'd really like to thank you for having me here today. And as you've heard, I do serve as administrative judge of the family court. And that means that I'm the chief judge who judge in charge of the family courts. And I often refer to New York City family courts as the finest courts in the universe. And I say that with full honesty. I say that because I mean it, and I say that because it's true. My vision for the New York City family court is that of a strong, vibrant, thriving, independent, professionally run, due process-driven court where there is respect for each and every person who comes to our courts for help. It is our expectation that there will also be respect for all of those who serve in and work in the family court, and that all cases will be addressed fairly and expeditiously. Before I address the actual topic that I was asked to talk about today, which is doing more with less in family court and the impact of the budget crisis on the Latino communities we serve, I wanted to briefly discuss the work of the family court for those of you who are less familiar. And forgive me to those of you who are the experts that know everything we do in family court, but I think it's important to know what we can do as a court and what we can't do. The types of cases we deal with in family court include juvenile delinquency cases. Those are the cases involving criminal acts that would be crimes if they were conducted by adults, but we have jurisdiction over children under age 16. If you are over 16 or over in New York State, your case, and you're arrested, you go to adult criminal court. PINS cases, person in need supervision cases, you may be familiar with those. Those are cases where children under age 18 who either not attending school or ungovernable at home and generally beyond the lawful control of their parents. Parents and others, including social work professionals, have the ability to file petitions in court seeking the court's assistance with those children. We also handle custody and visitation cases for children up to age 18 and guardianship cases for children up to age 21. Those cases involve issues of decision-making power and contact that parents can have with their children as well as other relatives they have with children. We also address family offense matters in family court. Those are domestic violence cases between intimate partners or other relatives. Those are the types of cases where orders of protection are issued in family court. We also handle child support. One of the things that most people don't know about family court is that the largest subject matter specialty we actually deal with are the support cases. You don't hear about that much, but it's true. 42% of the cases filed in family court are cases involving providing support to children. We also deal with paternity matters in family court, and that's, as you may be aware, a declaration of who is a child's legal father. We handle adoptions and foster care. Adoptions that result from foster care children becoming adopted after parental rights are terminated, as well as private placement adoptions in family court. We handle child abuse and neglect proceedings. We call these child protective proceedings. Those are the proceedings that in New York City, they were initiated by New York City's Administration for Children's Services, and the children are in care of foster care agencies. We handle termination of parental rights proceedings for children in foster care, which would enable an adoption proceeding. There has to be clear and convincing evidence that there is permanent neglect, abandonment, mental illness, or mental retardation, or severe or repeated abuse of the child in order to lawfully terminate a parent's rights. So those are the types of cases we handle in family court. And we handle approximately 250,000 petitions each and every year. But we who serve the family court realize that we're not dealing with petitions. We use the term petition because we're lawyers and that's what we do. We call it a filing and we think of it that way. But the truth is we know that we're dealing with 250,000 families in crisis. They're not petitions, they are families in crisis. We also know that it's so critically important, and it's part of my message as a leader of the family court, that we be consistently respectful and responsive to the needs of those we serve. We recognize that those who come to family court aren't there because they want to be there. They're there because they're in trouble and they have no choice. They have to be in family court. There are approximately 64,000 families currently, right this moment, appearing with active cases on our family court's calendars in the 5 boroughs, representing 88,000 children. We currently, and this is a result of budget decisions, we have never had a sufficient number of family court judges to serve. Right now we have more quasi-judicial staff than we have judges in family court. It would require legislation to add additional family court judges to the family court, and that hasn't happened. We have had the same number of family court judges in New York City for the past 20 years. Think about that. Caseloads have exploded. We've increased the amount of work we do by 42%. Yet we're expected to do the same amount of work with the exact same amount of judges we had 20 years ago. So although we are, by statute, we only have 47 judges serving in family court, our administrative leadership of the courts, the Office of Court Administration, has every year provided us with a few judges each and every year that we basically borrow from other courts. People who are elected to the civil court or are appointed to the criminal court spend 1 to 2 year periods in family court. And that impacts what we do as well, because while we're grateful for the help, and we could really use the help, imagine the time it takes to teach a judge who's not familiar with what we do in family court, the important work we do. And family court is one of those courts. I mentioned that we're a due process-driven court. We are a court of law. We're not a social service agency, but part of our training has to do with the social service industry, child welfare, and understanding social work issues. And to try to do that from someone who hasn't been in family court is quite difficult. So we have the judges who come and serve us, we train them well, and then they leave us after a year or two and we have a fresh new batch. So it's a constant challenge to keep up in family court. In addition to having judges that serve borrowed from other courts, we also have court-trained referees. And some of you who appear in court may appear before referees. Referees are quasi-judicial officers, and they do have certain authority to act in a similar way to a judge in certain types of cases. We also have support magistrates. In New York State, our child support cases are not handled by the judges. The appeals of child support cases are handled by judges, but our support magistrates handle the thousands of child support cases we have in our court. Now, before I get specific about the budget crisis and its impact on family court, I wanted to inform you of some important work that we're doing in family court, and I think you'd be interested in it. We have decided to use some of our resources and pay attention to the issue of disproportionate minority representation in family court. It is a thorny topic. What do I mean when I talk about disproportionate minority representation in family court? What I mean is that children of color are represented in family court cases have a disproportionate number to their numbers in society. We have overrepresentation of children of color in the child neglect and child abuse arena. I like to say when it comes to juvenile justice, we don't have disproportionate minority representation. But that's not good news because we have complete minority representation. The children who are arrested and go to facilities in New York City are almost all children of color. And there's something wrong with that. And oftentimes courts think that, well, we have to handle every case that is presented to us, so while we recognize that this is an issue, there's nothing we can do about that. I say no. Because when we adjudicate these cases as a court system, if we're interested in due process and fairness, we have to take a look at what's causing this disproportionate minority contact and disproportionate minority representation in family court. The reasons for our concern about these issues are obvious. hourly rates and other things. But unfortunately, I have to rely for general statistics on the Citizens Committee for Children because our state court system is not yet equipped. It's a data-driven society, but we're not yet equipped to talk about children and families of color in our foster care system, in our family court system, because we don't actually, while we may collect at certain points this information, it's not in a manner that I can tell you the percentages. And that's unfortunate, but we're working on that as well. But according to statistics compiled by the Citizens Committee for Children, at 47.4%, Latino children comprise almost half of all indicated reports of abuse or maltreatment in the year 2008. And in that same year, almost 30% of the children who were admitted into foster care were Latino. Similarly, the percentage of Latino youth in juvenile state detention facilities in 2008 was 31% as compared to 2% of white children. And the percentage of Latino youth placed for detention, that means after arrest and before adjudication, is 28% in New York City, as compared to 4% for white children. Of the 5,837 youth admitted into custody in New York City, close to 30% came from the Bronx. And you know what that means. It's the county with the largest Latino population in the city. Furthermore, Black and Latino children, and I saw a slide up there making reference to the impact that the crisis had on Latino communities. Black and Latino children remain more likely to live below the federal poverty level than white and Asian children. And in 2008, 35% of Latino children and 29% of Black children lived in households earning at or below the poverty level. This is very disturbing news. So in terms of what the New York City Family Court can do, we have a citywide multidisciplinary effort to address the overrepresentation issue of children and families in foster care. And it's being led by our own Bronx Family Court Judge Gail Roberts, with local work going on in each of the boroughs to try to address these thorny issues. Now I'll get to the topic that you asked me to talk about today. And that has to do with the recent challenges that we've been faced with as a result of our budget crisis. That's being felt everywhere. We had an early retirement incentive that was basically mandated upon the court system in November of 2010. This incentive caused a lot of our seasoned personnel in the entire state court system, but particularly family courts, to leave us. Not only did we lose a number of people as a result of retirement, but what happened was a lot of people who worked in family court made lateral moves, not receiving any more money, but chose to leave us to go work in the other courts in New York State because as a result of the retirement incentive, there were openings all over. This was unfortunate to us because, you know, the truth is that anyone doing anything, anywhere in the New York City Family Court is the hardest working employee in the court system. It's just harder to work in the New York City Family Court. That goes from our court officers to our clerical staff, to our social work staff, the few social work staff we're blessed to have. Everyone works harder when they have to work in family court. So when there was an opportunity to move and go to another court, we lost a lot of people. And unfortunately, we weren't able to fill many positions because as soon as we had this early retirement incentive, we had a budget crisis that hit the court. Originally, we had the expectation that we would be losing $100 million in the New York State court budget. And that would have been a really difficult thing for us to do because our budget is 98% people. That's what we do in all of the courts in New York State. Most of the money are personnel costs. So before we were able to even fill our positions, we had a budget crisis that mandated that we actually lay off personnel. Court staff were laid off in every single court in the state of New York. And what was so disturbing about this for many of us is that you understand people take civil service type jobs. People who work for government and who work for the courts choose that work because, of course, they want to work in public service, but also there's a level of stability that is associated with working for the court do what we did. And I was personally there when we laid off court personnel, and these are hard-working personnel, and we laid them off. We even laid off a social worker working in King's Family Court. And we have so few social workers helping us do the critical work we do in our courts, but it was a choice that wasn't made by that particular choice wasn't made by me, but it was a choice that had to be made. So we were compelled to cut non-personnel expenses to the bare bones, and we laid off back office staff and personnel. And guess what? We are still under a long-term hiring freeze. So if someone gets sick and works in the New York City Family Court, we can't hire someone and stops working or retires. We can't rehire someone to replace them. So we can keep being compelled to do the work that we're expected to do with fewer resources to do it with. We've implemented mandatory overtime restrictions as a result of the budget crisis. And this is the one thing that I'm not going to say I'm sorry for, quite frankly. We have a statewide mandate that we must close our courtrooms by 4:30. That doesn't mean, for those of you who appear in courts and it looks as if, wow, they get to end their court day at 4:30. That's not what's going on. When we close shop to you at 4:30, our personnel have to push the orders and draft the orders of protection and the remand orders that place children in foster care. There's the back office work that we have to do by 5 o'clock. But by 5 o'clock, not 5:01, 5 o'clock, everyone must be finished their work. And there's a reason for that. New York, we in the New York City Family Court spend millions of dollars every year on overtime costs alone. If we do not eliminate courtroom overtime, which we've done, and I'm very proud of that, if we were not able to do that, every hour in overtime, every minute in overtime, I see a human being, and I see the faces of the people that we had to lay off. There are more layoffs coming if we were not able to put overtime under control. So I'm pleased that we've been able to do that, but it's come at a cost. There are fewer hours in a court day to do the important work that we have to do. Every day at about 4 o'clock, I am the only person in the New York City Family Court that's allowed to approve overtime, because if there is a drastic emergency, on a rare occasion, I will indeed approve overtime to make sure that a courtroom can stay open to address an emergency. I've only done it once or twice and only allowed 5 or 10 minutes, because I recognize that if you're not able to end overtime, more people will be laid off. If we lay off more people, the children and families we serve will be hurt even more deeply. But the reason I said I'm not unhappy about the closing the courtroom every single time, those of you who have ever had to appear in family court know that sometimes you would appear there early in the morning and wait and hours. Children and families are waiting along with you. And I keep using the word respect because that's just my mantra. It's disrespectful. It's disrespectful of you. You could be going and doing your social work, right? Waiting. The families and children we serve have other places to be. So I'm glad that there is an end to your day. How do we fuss at you for not obeying the order we made for keeping you in court till 8, 9, 10 o'clock at night? We used to do this in family court. It just wasn't right. So that's the one benefit that's actually an unintended consequence, but it's one. I don't want to go back. We're not going back to the days when you were in court until 8, 9, 7, 8, or 9. You couldn't do your work, and you have families as well. So now these are the very specific cuts that we've suffered in family court to understand what we're dealing with. There's no more night court in the New York City Family Court anywhere. We used to have night court. Now, we didn't conduct trials at night. What we did at night, families who had jobs were able to come to family court at night and file their petitions and start the process. We can't do that anymore. It costs too much. We eliminated overtime. We eliminated night court citywide. We eliminated our child protective mediation program, a program that was critical to helping families negotiate settlements and foster parents working with parents to try to address issues of concern. We've had to eliminate the child protective mediation program. As I mentioned, we laid off the social worker, which harms us as a whole because we had so few in family court. We had a judicial hearing officer